wages. So in section 5 of the code, there is a line single, no employer shall pay to any employee wages less than the minimum rate of wages. You see, employee means starting from unskilled to your administrator. Remember, we discussed all these categories. Here it is not using worker. The law is using the word employee. It is not using the worker. So no one shall be paid less than the minimum rate of wages notified by the appropriate government. Appropriate government we discussed, it is your state government in maximum cases. Only in a few cases it is central government, but otherwise state government. This also we discussed specifically. So whatever is your government defines. So what does this mean? The another legal meaning of this wording is that for you, your minimum wages shall be defined by your appropriate government. Your state government shall define minimum wages. So that practice is continued. And in next section 6, it says that subject to section 9, we will study that appropriate government shall fix the minimum wages. Means Gujarat, Jharkhand, Haryana, Punjab, Delhi, every government shall fix the minimum wages. See why I am enumerating these? Because many people have now a concept of floor wages. Now I would also remove the fog over the floor wages today. मुझे वो भी जाले साफ करने आज फ्लोर वेज के. Okay, so this section 6 is live. ये डेड नहीं हुआ है. बहुत से लोग कहते हैं सर मिनिमम वेजेस नहीं रहेगी, फ्लोर वेजेस होंगे अब. अरे धत्ता, कुछ भी नहीं, फ्लोर वेजेस कुछ भी नहीं है. डोंट वरी, योर सेक्शन 6 is live, section 5 is live. They cannot be overruled. So मिनिमम वेजेस थी, मिनिमम वेजेस हैं, मिनिमम वेजेस रहेंगी. Appropriate government shall fix the minimum rates of wages, your state government, payable to the employees in accordance with the provision of section 8. The appropriate government shall fix minimum wages for time or piece rate of work. And when the employees are employed for piece work, the government shall fix the piece rate wages. Minimum wage or time-based wages, they shall be based on hour, day or month. So this government can define. So they have, and the rates of wages fixed by hours of wage, they shall be as the calculation rate formula shall be government shall be giving that. So I'm not going in that detail, but this section empowers this appropriate government, means state government, appropriate government to fix the minimum rates of wages, number 1, to fix on time or piece rate, number 2, or for piece rate, how they will be fixing minimum rate for them, and piece rate hourly, daily or monthly they would fix. So this is how they would be fixing the piece rate and empowered into that. Now for fixing the minimum wages rate, the government shall take the skill of the workers. That's why you have minimum wages for unskilled, semi-skilled, the skilled or highly skilled, and in the categories. So the law defines, section 6 of code defines, not the rules, that categories would be unskilled, skilled, semi-skilled, highly skilled, 1, and geographical areas. That's why in some of the states, they are defining minimum wages for A region or A zone or B zone or C zone. Example are our Gujarat state and Maharashtra state. Yes, friends from Gujarat and Maharashtra, please confirm. You have wages on the geographical area in your states? Zone A, B, C, yes or no?
Yes, sir.
Yes,
I am
sir.
from Gujarat. Yes, sir.
Gujarat में है.
Right. So how the governments are doing? Because law is empowering them on geographical area. And interestingly, see the each word important. It says or, both. So what your government is doing, Gujarat government is doing, geographical area A, and here minimum wages of unskilled, semi-skilled, skilled, and all this. Geographical area B, again for them different rate. They are using both criterias, geographical criteria and skill criteria. Whereas state governments like Haryana, they don't divide the wages on geographical area. because being a small state. However, it is not practical. The minimum wages should not be same as that of in Gurgaon, as that of in district Sirsa in Haryana. They should be different. But Haryana government is not defining the wages on the geographical area. They are only defining wages based on skill. And in addition to this rate of category, they shall take into account the arduous nature of work, temperature, humidity. So in many state government, like you go to some of the states, they are defining minimum wages for cement industry, for steel industry. So they are defining based on that industry or that what kind of nature do they have. And we will be just discussing next week. They are defining what is the criteria of fixing minimum wages. So please be alert next week. Tell your friends. Next week, I would let you know how the minimum wages are decided. What is the criteria? कैसे वो 15,222 होती हैं, कैसे बनती हैं, वो क्या क्राइटेरिया है, कितना इसमें खाने का है, कितना इसमें रहने का है, कितना इसमें बीमारी का है, कितना इसमें दूध का है, कितना इस बच्चे स्कूल का है, और कैसे बनता है ये. देयर इज ए डिफाइंड क्राइटेरिया बाय द लॉ. ऐसे नहीं मिनिमम वेजेस बन जाती. जैसे वो ऐड आता ना, ऐसे नहीं मैं रजनीगंधा बन जाता है, ठीक है, तो ऐसे ही नहीं मिनिमम वेजेस बन जाती. देयर इज ए क्राइटेरिया फॉर दैट. So that is defined in the rules. So while in the rules, I will be discussing that. Okay. Now section 7, the minimum rate fixed by the appropriate government, they shall consist of basic rate of wages. So that's why you have basic wages. And this basic wage of rate shall be adjusted at appropriate intervals. Appropriate intervals after every 6 months. And this would be linked with the cost of living index. What you call as consumer price index number, you have that. Or the government may define basic rate of wages without cost of living. Or they may define all-inclusive rate, including basic, cost of living, everything. So it is giving the full autonomy and authority to the government that they can either define basic wage or they can define DA also. So it is giving full authority to the governments how they define. So the cost of living allowance or cash value, they shall be also taken into consideration, and including the essential commodities which are provided. This also has been referred into the rules. So while rules, I will be briefing you that how the minimum wages under section 7, how they are defined, what is the criteria of food and consumption, all those things. So here the procedure is also given. So in fixing the rate, they would consider the as the case, and they would fix the publish the proposal, and they would make a committee and subcommittee. So minimum wages are decided by committees and subcommittees, and these committees, those who are deciding minimum wages, they would be having employers representatives, employees representatives, and independent persons. So this is the ratio. So not of our concern, can be of concern that tomorrow anyone of you and me can be member over there. So it is that how they would be. Now here is a very interesting thing. I have little highlighted it. The appropriate government shall review or revise the minimum wages ordinarily at an interval of not exceeding 5 years. They would revise minimum wages. See, you have every 6 months minimum wage revision. No. Every 6 months minimum wages are not revised, my dear friends. 6 months only it is consumer price index number or the cost, it is aligned. The minimum wages are revised once in 5 years, which many governments are missing this 5-year period. Like in Haryana government, Gajendra, when the minimum wages were revised? In 2015. And now once the workers went to the agitation in Manesar, in Gurgaon, then in 2026 they had to revise it after agitation. So since 11 years, government was just giving consumer price index, fixation to that. So at one point of time, it was felt that they are very less. This agitation went to Noida also. So the law says that appropriate government shall review or revise the minimum wages in a interval not exceeding 5 years. So governments are fault because they have not revised it. So they were less and people agitated. So this is a basic mechanism how the minimum wage would be fixed by the appropriate governments or the state governments, how they would be revised, what they would constitute, when they would be minimum fixed. Further, I would be discussing in the rules what the criteria is given. Here is your interesting formula. The authority may tomorrow challenge that if the component has not been enumerated, how you are included in the wages. They have very cautiously have enumerated list of the component which can be given to the employee, which includes the special expenses, not the special allowance. See, the entire definition of the wages with 50-50 concept is based on 2019 Vidya Mandir and Surya Rosni case versus RPFC in the Supreme Court, where the Supreme Court and the authorities, they observed that employers entire in India, employers are keeping the basic wage minimum less to less, and with this basic wage as minimal, the employers are cheating with the employee, basic salary. Employees are getting less social security benefit, including the provident fund, including the gratuity, including the leave encashment, including the bonus, whatever is given, that is given on basic salary. So they found that employers are keeping basic salary 25%, 20%, 30%. So that thought process only changed this law that employers are manipulating the salary wages by keeping the basic wage minimal and reducing the employees' welfare contribution, social security contribution as less or less or less or less or less. So with this, the law has come with an idea. Now let me fix a bar that employer cannot give less than 50% of basic salary, so that employees get higher and higher and higher and higher social security and the welfare benefits on the basic salary. That has been the intent of the law. Again, please note down my words, they are being recorded. आप किसी भी हाई कोर्ट सुप्रीम कोर्ट के डिसीजन में ऐसा ही वर्डिंग पाएंगे. 1 साल 2 साल 3 साल के बाद याद कर लेना मेरी बात को. The intent of the law has been to make basic salary higher so that employees get better benefit. But yes, law ने थोड़ी सी गलती कर दी. उसने परक्विजिट और रिइंबर्समेंट वर्ड को नहीं लिखा. दैट इज द इंटेंट वेयर वी आर यूजिंग. कहता है यू आर अपॉइंटेड सो एंड सो, प्लेस सो एंड सो. उसके बाद मेरा अगला क्लॉज आता है, क्लॉज नंबर 2, कंपनसेशन एंड बेनिफिट. क्लॉज नंबर 2A, इन द कैपेसिटी ऑफ मैनेजर, जनरल मैनेजर, वाइस प्रेसिडेंट जो भी है, you shall be paid compensation and benefit as per given annexure A to this appointment letter. This compensation and benefit shall be subject to various statutory deductions and other contributions which are required and mandated by the law, including income tax, PT, welfare fund, ESIC, or any such contribution as and when promulgated and notified by the law. Full stop. 2B, in the capacity of manager, general manager, VP, or जो भी है, you shall also be entitled to various perquisites and reimbursements as entitled to your grade as enumerated in annexure B to this appointment. Full stop. These perquisite and reimbursement shall be governed by the internal company regulations and the various income tax regulations notified from time to time. Clause 3, प्लेस ऑफ पोस्टिंग, क्लॉज फॉर लोकेशन, जो भी आपका उसके अपॉइंटमेंट लेटर में आपने 36 क्लॉज देने दीजिए. ये जो आप कंपनसेशन बेनिफिट है, रेम्यूनरेशन का जो क्लॉज है, मैंने उसको 2 भागों में बांट दिया है. एक भाग में मैंने C&B कर दिया है, जो मैं उसको वेजेस का पार्ट कहूंगा. एक भाग में मैंने परक्विजिट रिइंबर्समेंट कह दिया है, जो मैं उसको अलग से दूंगा. ए जो कंपनसेशन बेनिफिट है वो मैं सैलरी स्लिप में दिखाऊंगा, बी में सैलरी स्लिप में नहीं दिखाऊंगा. Second clause is that the second proviso is that for the purpose of equal wages and for the purpose of payment of wages, and here इस लॉ में 4 पार्ट हैं. एक तो है इक्वल रेम्यूनरेशन, एक होता है पेमेंट ऑफ वेजेस, मिनिमम वेजेस, एक है पेमेंट ऑफ बोनस. ध्यान रखिएगा, इस एक्ट में, इस कोड में 4 पार्ट हैं. तो ये कह रहा है कि जहां पे भी आप इक्वल वेजेस की बात करेंगे, पेमेंट ऑफ वेजेस की बात करेंगे, तो clause D, F, G, H shall be taken as computation for computation of wages. देखिए wages केवल दो ही कंपोनेंट हैं, तीन ही हैं wages means basic पे, डीए एंड आरए। आरए होता नहीं इसलिए हम दो ही बोलते हैं, चलो वेजेस के दो ही कंपोनेंट हैं। बट ये कहता है कि अगर आप इक्वल रेम्युनरेशन की बात करते हैं, आप पेमेंट ऑफ वेज की बात करते हैं, तो ये चार कंपोनेंट भी और इसमें जोड़ लीजिएगा, चार कंपोनेंट इसमें और जोड़ लीजिएगा। ये सेकंड प्रोविजो है डी एफ जी एच। मैं आपको फिर दोबारा डिटेल में आता हूं, इंस्टेड ऑफ गोइंग एज बाय वर्डिंग्स, लेट अस सी क्या कहता है। और फिर मैं आपको फिर वही बहुत बड़ा मैं आपको गूढ़ रहस्य बताऊंगा, दी वन ऑफ द वेरी ए रिमेंबर, हु विल टेल मी कौन कौन से कंपोनेंट थे? डी, एफ, जी एंड एच। यही थे ना, डी एफ जी एच। लॉ सेज दैट इफ यू आर हैविंग एनी कंसर्न अबाउट इक्वल रेम्युनरेशन और समवन सेज कि मुझे वेजेस नहीं मिला या मेरी वेजेस काट दी, उसके लिए जो ए कंपोनेंट है तीनों और बी के चार, डी एफ जी एच, ये मिला के वेज बनेगी। दिस मीन्स इफ यू आर हैविंग समवन एज ए वेजेस कंसेप्ट, तो बेसिक होगा, ये होगा, कन्वेंस अलाउंस होएगा, एचआरए होएगा एंड सेटलमेंट यूनियन के साथ जो अमाउंट वो होएगा, ओवर टाइम होएगा। डी एफ जी, ये सब मिला के वहां पे वेज काउंट होएंगी। तो अगर कोई वुमन कहती है कि जी मुझे मेल के बराबर वेजेस नहीं मिली, तो आप इन कंपोनेंट को ही कंपेयर करोगे। कमीशन को कंपेयर नहीं करोगे बिकॉज ये एम्प्लॉय टू एम्प्लॉय डिफर करेगा। पीएफ को नहीं करोगे बिकॉज ये बेसिक सैलरी डिफरेंट हो सकती है, पीएफ कंट्रीब्यूशन हो सकता है, स्पेशल एक्सपेंसेस सेपरेट हो सकते हैं। देखिए इंटेलिजेंट लॉ ने बाहर कर दिए हैं। हाउस रेंट भी डिफरेंट हो सकता है, बोनस भी डिफरेंट हो सकता है, इसलिए लॉ ने ये 6 कंपोनेंट ही रखे हैं वहां पे, और 4 बी में से 2 वहां पे। जो कोई कहता है कि इक्वल वेजेस नहीं मिली, तो हम इन 6 कंपोनेंट के बीच में कंपेयर करेंगे। Clear? This is the second proviso. This is what the law says as per the second proviso. D, F, G, H. HRA, conveyance, overtime, and settlement award, settlement amount. एक चीज और मजेदार चीज, very careful and very विशेष, are you here? Now second thing, again, the second proviso has one more component. It says for the payment for the purpose of payment of wages. I'm highlighting these words, ladies and gentlemen, please note down. I would be just coming in the payment of wage section, chapter 4, where the law says that an employee has to be paid wages within 2 working days of the termination from the company. Again, a deep consulting advice. People question, sir, how to pay wages within 2 working days? I have branches, I have regional offices, the full and final has to come, laptop has to come, charge order has to come, then the branch head has to sign, then the regional territory has to sign, and then it has come, then financial head has to sign. I cannot process, sir. The system is not there that I can pay wages within 2 days. Then I say, do you want to follow the law? You can pay within 30 days as per your current practice. No, sir. I am a 100% law abiding company. मेरी जॉब चली जाएगी सर, अगर ये लॉ की रिक्वायरमेंट है विदिन 2 वर्किंग डेज, तो मुझे पे करना ही पड़ेगा। तो बट सर कैसे करूं? I told you one of the solution out of the equal pay, same work, same pay. I gave you the solution how to avoid that. Today also I'm giving the solution that how can you pay wages within 2 working day of that clause. Remember, only these 4 component are wages for payment of wage concept. I repeat, for the payment of wage concept, these are the 4 component plus basic and DA. Only 6 component are required for the payment of wage concept or equal wages concept. Now within 2 working days, you pay these 6 component to the person, and rest you pay within 30 days as per your compensation and benefit policy, which I told you that is must. These component you pay within 2 working days, 6 component, and rest component you pay within 30 days. You are compliant legally, you have abided the law to pay wages within 2 working days, and you have cheated the law. It is a cheat sheet by not paying the other wages. आप जब लैपटॉप देंगे then I will pay you.